You are listening to the Final Say Radio Show, a Rappaport Media production, with your host Brett Rappaport and co-host John Rappaport.
We have our first guest of the program today, and I want to welcome back to the Final Say Radio Show Hans von Spakovsky, who is a legal scholar with the Heritage Foundation, and he's spent absolute years covering different civil rights, civil justice, First Amendment, immigration issues with regards to law, of course. So, Hans, first, welcome back. It's a pleasure to have you joining us.
Well, I appreciate you inviting me back.
I think this is a very interesting case, and I'm really glad that you were able to join us on such short notice, that the Supreme Court in a 5-4 decision, which I think is a little startling to me, but that's another story, came out in favor of towns, when they're having their meetings, being able to start with an opening prayer, and they consider this to still be constitutional. And I think when you look at the reasoning that some of the justices had, both for and against, I thought that was pretty interesting as well.
Well, no, I agree with you, and this involves the town of Greece, New York, and like a lot of places, and like state legislators everywhere, and the U.S. Congress, they open up their town meetings with a prayer. And the way they find folks to do it is they basically had a clerk of the town go through a directory of all the religious institutions and churches in town and would basically make random phone calls to see if folks wanted to do it. So, there was no evidence of any kind that they were favoring, one particular religion, one particular church, or anything like that. But the folks sued, saying it made them uncomfortable to have to attend these meetings, and it violated the First Amendment to force them to be there when this happened. And, as you said, the Supreme Court disagreed. I have to agree with you. I'm amazed at the, frankly, hostility towards religion shown by the dissenting judges in this case, and it's not a surprise, but when you think that this was only upheld by one justice, it tells you how important the nominees are to the U.S. Supreme Court.
No, that's a great point, and it is a little shocking because we're a country that's founded and has a tradition of a Judeo-Christian background, and all of our founders had supported some sort of religion, and they all looked to it for guidance and faith in crafting our Constitution and the laws that govern our nation. And to me, I just don't understand why you would be against something that is, for the most part, a positive thing. Having some sort of moral foundation and faith in something positive, to me, would usually be good. Why these people are uncomfortable, I mean, I guess that's their right. But because they're uncomfortable, the rest of us should have to forgo our religion. It's a little over the top.
Right. Well, it is. And, some of the justices pointed out that, look, it's very clear that there's no coercive behavior going on. It's not that the town or the government is establishing a church. They don't force anyone to participate. So, the fact that you might be offended is not a constitutional right. And they went through, the majority did, the great history of this. I mean, look, the first Congress immediately hired chaplains for the House and the Senate to lead Congress in prayer. And like I said, that this is a standard of, I think, every state legislature in the country. So it was clearly important to the court that we have a long history of doing this, and that clearly to them says this was considered acceptable behavior, even by the framers of the Constitution.
Yeah, that's right. Now, one interesting thing that they try to say here is, in defending the ability to do so, it says if you went the other way and your local town or government entity had to monitor what was considered to be proper speech, then you get into something that's probably far worse than anything you're complaining about in the first place. And I think that's absolutely right.
Yeah. One of the claims that was made in the case was that, well, this would have been okay if it was a non-denominational type of prayer. And as you said, what the court said was, okay, well, then you put judges and local towns and others in the position of judging what kind of religious speech is acceptable and what isn't. And of course, that would be a far worse result. And the idea that you could only issue a prayer that absolutely everybody in the room agrees with would mean that you would never have any prayers. I think those are all very important points to keep in mind, and thank goodness, towns now will be able to do this.
What's interesting, Hans, is we look at our currency, we look at the fact that POTUS himself or herself eventually is sworn in on a Bible, right? And, of course, they get to choose their Bible. I think we have significant precedence for this. I wanted to ask if you would touch on, it appears to me that SCOTUS placed a relatively high bar on the burden of proof using the coercion clause, if you will. Can you please explain to our audience the significance of this clause and why you think it was the right approach for the majority decision?
I think that is a very important point because, as you know, not just in this, but in so many other instances in our modern life today, people go to court and they object when they're merely offended at something and don't like it. And, if that was considered sufficient to show a violation of a constitutional right, it would just be a disaster. And the court, went to great lengths to talk about coercion being a necessary part of any kind of analysis to see whether or not a government has violated the First Amendment's prohibition against establishing, a state or government religion. And I think that's a very, very important key to the decision and to any future cases applying these principles.
Now, isn't this also a very important distinction between the virtues of America being a republic as opposed to a pure democracy, so that we have the best balance of being able to protect the minority rights without necessarily allowing one single person, for example, of let's say a Buddhist or Islamic or Jewish origin, to be able to turn around and tell a town of 75,000 people with a large majority that because I personally am offended, nobody can have any context pertaining to a belief or a praise of faith at all.
Yeah, no, that's very true. And the dissenters in this case, led by Justice Kagan, they tried to make a big deal over the fact that almost all of the individuals who came in to offer prayers were from Christian religions. Well, it turned out the reason for that is that there are almost no other religious institutions in this small town. In fact, there's a very small Jewish population, but there is no synagogue. They go to somewhere else to worship. So again, it wasn't that they were intentionally excluding other religions. It's just that there are hardly any other religious institutions in this particular small town.
Hans, if we could, in the few moments we have left, and you have wrote about this as well, there was an interesting Supreme Court case a few weeks ago, and that had to do with the Michigan banning racial preferences. And I thought this was a very interesting case. And I was just curious your opinion. If you think, I know you brought it up, but what's the likelihood of other states following suit in similar laws, and do you think this will have an impact on other college campuses?
Oh, I think it will. I think this will give inspiration to citizens in other states to move forward with this. Particularly, I'm hopeful that Tea Party organizations will pick up on this, because this is something they can do at the state level to affect real change in this country. And what's interesting about that case is you had really the same dissenters as you did today, just very, very angry over the fact that the court upheld a state being able to ban all racial discrimination. And they made the odd claim that by doing that, you're going to engender more racial discrimination, which is frankly just illogical. It doesn't make any sense.
Yeah, you're absolutely right, and I think the terrible thing is that it comes down to, and it doesn't always go in a direction we believe is the correct way, but when it comes down to the Supreme Court having to ultimately decide these things, and sometimes I shake my head wondering why is this stuff even in the courts in the country that is supposed to be the beacon of freedom and free enterprise and all the other things that we're constantly speaking of. I don't know.
Well, you know why? It's because, unfortunately, many liberals, when they can't do things through the democratic and legislative process, they go to the courts, and they want to use the courts as a way of getting around the democratic process. That was certainly the case in Michigan, where the majority of voters voted to approve a complete ban on all racial discrimination.
Yeah. As John brings up the point, yes, until it works against them in the courts, then they're upset.
Very true.
Well, I think it's very interesting. I was kind of worried with the Barack Obama's appointments to the Supreme Court. I was concerned with the types of rulings and the makeup of the court going forward. And in this case, I think maybe Ruth Bader Ginsburg would possibly be the next one to step down, although she said, I believe last week, that she had no intention of stepping down yet. And of course, that if she was replaced, that would be essentially replacing a liberal with a liberal. But I am concerned the president has 2.5 more years, or better part of 3 years left. And I just kind of hope that things just remain the same and we get through this period of time, because God forbid, or God help this country on decisions like we've recently seen, if he gets to put another person or two on the court, and one of them happens to be replacing one of the people we consider to be the more conservative Supreme Court justices.
Yeah, I'm not sure the country in the long run would survive that. Although we should all keep in mind that after 6 years in office, the president has literally appointed hundreds of federal judges to the lower courts, and that's why we're getting some of the bad decisions we're getting all over the country on particular issues.
An excellent point, and some of those people will be the future judges who are considered for such a post.
That's right. That's exactly right.
Yeah, it's very, very interesting. Are there any other decisions that we could expect over these coming days while they're in session that we should be looking out for?
Well, yeah. I mean, another really, really important case on religious freedom, and that is the Hobby Lobby cases. Those are the cases involving the HHS mandate for abortion and contraception coverage, and that case was argued just a couple of weeks ago. And so at some point before the end of June is when the Supreme Court ends its term, we will get a decision on that too.
That'll certainly make the news media rounds.
Yeah, well, that may get the most attention of almost any case. Or plus, one other really big case, remember, is there's a case before the court about the recess appointments that the president made to the National Labor Relations Board, which everyone says he was not able to do constitutionally.
Quick question on that one. If, in fact, they ruled that he wasn't able to do that, how would that impact some of the decisions that were made by those appointees?
Well, I think it would give any company or union, probably companies, that were affected by a decision rendered by the National Labor Relations Board at the time these people were illegally serving, they could go to court and claim that decision was null and void.
Very interesting. I guess we're going to have to wait and see how that one plays out. Well,
that's right.
Hans von Spakovsky, I want to thank you so much for joining us. And if you can, please give the website for Heritage or anything else that you are working on, and we'd be happy to help promote that.
Sure. It's heritage.org, and I would like to say I got a new book coming out in June about the Eric Holder Justice Department and how they've conducted themselves as lawyers and as a department over the past 6 years, out June 10th.
Well, excellent, and we'll have to schedule you on to discuss some of that.
Well, I'm happy to do that.
Okay. Again, Hans von Spakovsky, thank you so much for joining us today on the Final Say Radio Show. We look forward to having you back soon. Take care.
Thank you.